You know, we use the word theft all the time, right? Maybe you joke that a friend stole your joke, or you borrowed a pen from work that never quite made it back. But in a courtroom, that word is serious business. The law doesn't just see one crime, it sees a whole family of them, and each one has its own very specific DNA. So let's grab our legal microscopes and figure out what theft really is.
So, here's our game plan. First, we're going to meet the four main faces of theft. Then, we'll break down the crime itself, what it's actually made of. We'll look at the price of getting caught, see how a defense is built, and finally, we'll put you in the judge's seat.
All right, first up, the lineup. You'd think a thief is a thief, plain and simple, but for a prosecutor, it's way more complicated. They have to prove exactly how something was taken, because the law has four very different categories for this stuff.
Now, at first glance, these all seem the same, right? Taking something that isn't yours. But the law, it zooms right in on the how. Was it a simple grab and go? A betrayal by someone you trusted? A clever con game? Or was there force involved? That one little detail changes everything, creating completely different crimes.
So let's start with the classic, larceny. This is probably what you think of first. It's your basic shoplifting or pickpocketing. You physically take something, you walk away, and you have no intention of ever bringing it back. Simple as that.
Next up, we've got embezzlement. This one is theft from the inside, and the key word here is trust. Imagine an accountant who has legal access to the company's money, but they start secretly moving it into their own bank account. See, they didn't have to break in, they just had to break a trust, and the law sees that as a really big deal.
Then there's fraud. This is the crime of trickery. Instead of using force or stealth, a fraudster uses words, lies, and deception. They convince you to willingly hand over your money or property because of some false promise. It's theft by persuasion, and it's incredibly effective. And finally, we have robbery. This is where the law draws a very, very bright line. Think of it as larceny, but with one terrifying ingredient added in: force, or the threat of force. It's the difference between a pickpocket and a mugger. And that one element, the violence or the fear, launches it into a much more serious category. Because now it's not just about property, it's about a person's safety.
So we've met the four types, but how does a prosecutor actually get a conviction? Well, it's kind of like following a recipe. And if they want to serve up a guilty verdict, they have to prove every single ingredient, beyond a reasonable doubt. Here are the three core ingredients on that recipe list. First, an unlawful taking, the physical act. Second, of another's property. Pretty obvious, you can't steal your own stuff. But it's this third one, intent. What was going on in the person's mind? That's the secret sauce, and honestly, the hardest part to prove.
To make this all feel a bit more real, let's follow a quick case study. Meet Alex. We've got clear security footage. Alex goes into a store, puts a laptop in their bag, and walks out without paying. Seems like we've checked off the first two boxes, right? Unlawful taking of another's property. Case closed? Well, not so fast. That's only half the story.
This right here is the million-dollar question. We saw what Alex did, but the law is absolutely obsessed with what Alex was thinking. There's a fancy Latin term for it, mens rea, which just means guilty mind. And if you can't prove there was a guilty mind, you don't actually have a crime.
And here's the kicker. For it to be larceny, the prosecutor has to prove that Alex intended to permanently keep that laptop from the store. What if Alex was just going to borrow it for a school project and bring it back? Or what if they genuinely thought it was a prize they'd won? See? If that's the case, there's no guilty mind. The entire case can literally rise or fall on what you can prove about what was going on inside Alex's head.
Okay, but let's say the prosecutor can prove intent. What happens next? What's the penalty? Well, in the world of theft, it's not one size fits all. It often boils down to a single number, the price tag on the stolen item. The law often comes down to some really simple math. Now, these exact numbers change from state to state, but the idea is the same everywhere. That price tag draws a line in the sand. If Alex's laptop was worth, say, $999, we're talking about a misdemeanor. But if it was worth $1,001, it jumps over that line into a felony. A couple of bucks can literally change the entire course of someone's life.
So what's the real difference between a misdemeanor and a felony? Well, the consequences are like night and day. A misdemeanor might land you in a local jail for up to a year. A felony, though? That means state prison time, often for many years. Plus, a felony conviction can mean losing fundamental rights, like the right to vote. The stakes don't just go up, they totally skyrocket. Okay, so we've seen the crime from the prosecutor's point of view, but an accusation is just the start of the process. So let's flip the script and look at how a defense gets built, because there is always another side to the story.
So how do you fight a theft charge? A defense attorney's job is basically to find the crack in the prosecutor's recipe. They try to show that one of those essential ingredients, like intent, is missing. And these here are some of their most common tools, each designed to tell a totally different story about what really went down.
Let's jump back to Alex for a second. What if Alex says this? This is called a mistake of fact defense. Alex isn't denying taking the laptop. They're saying they had a genuine, honest belief that they were allowed to have it. And if they really thought it was a gift, well, then they couldn't have had the intent to steal, could they?
Or what about this version? This is a consent defense. Here, Alex is arguing they had permission from someone in charge. If the store manager actually said, "Go ahead," then that unlawful taking ingredient just vanishes. And just like that, the prosecutor's whole case could completely fall apart.
All right, we've seen the crimes, the ingredients, the stakes, and the defenses. Now let's put it all together. It's time to step into the courtroom for the case of Alex, and this time you're the one wearing the robe. So what's the verdict? Is Alex guilty or not guilty? The only real legal answer is, it depends. The entire case balances on these questions. Can the prosecutor prove what was in Alex's mind? Does that price tag push it into felony territory? Can the defense create reasonable doubt? This is the reality of the law. It's not some simple math problem. It's a complex puzzle of principles being applied to a very, very human story.
And all of this leaves us with a huge question for the future. I mean, these laws were written for a physical world, a world of wallets and laptops you can actually touch. But how do you take and carry away a piece of code, a digital identity, or an NFT? Our whole idea of property is changing faster than ever. So the great legal challenge of our time is going to be figuring out how to stretch these old-school laws to fit a digital world the people who wrote them could never have even dreamed of.